All right, and we'll go ahead and get started. Today, our speaker is John Carney. He's the Chief Technology Officer and the lead digital forensic examiner at Carney Forensics, where he's been assisting clients with electronic and mobile device evidence for the past 11 years as an expert witness. He graduated from the Massachusetts Institute of Technology Media Lab with a Bachelor of Science degree and earned his JD at Mitchell Hamlin School of Law. He is a federally and state licensed attorney in Minnesota. And I will turn it over to John now for our presentation.
Thank you, Sarah. I appreciate the introduction. And welcome all of you who are attending from all over the state to this continuing legal education session. I'm going to be talking to you today about social media evidence. And from multiple sources that we'll be going through in the next hour or so, and look forward to doing that with you. I ordinarily open this presentation with a 2 to 3 minute YouTube video on social media, which is quite exciting and interesting, but we chose not to try and play it here over the internet today to keep it simple, but some fascinating messages in this video, and I encourage you in the PDF document that Sarah has available, that you consult that PDF from these PowerPoint slides and take a look at the link here at the bottom and check out the YouTube video. It has some really interesting points of interest in the popular culture about the superiority of social media as an activity on the internet and the number of people who subscribe to social media sites. One of the depictions that I saw, I just looked at it a few moments ago, in terms of population, the country of China, right, the most populous nation on earth, both Facebook and YouTube have subscribers in excess of the population of China. Lots of other interesting statistics that might help you to appreciate how ubiquitous social media has become in our society today. I wanted to cover with you today this brief agenda. We're going to talk about some social media sites, some that you've heard of, some you may not have heard of, and then talk about some of the characteristics of social media sites and therefore the evidence that can be derived from them. I call it the new confessional because it speaks to the candor, the openness, and the transparency of communication on social media. Understand we have assistant county attorneys and paralegals and law clerks, as well as other state and local officials who may be involved in law enforcement. We're going to talk about some law enforcement usage and best practices for social media, and community that you might consider joining if you aren't aware of a few of these things. And then the social media evidence itself, we're going to talk about case evidence, case examples of both prosecutorial and criminal. There's also social examples as well. We could have examples from criminal, prosecutional and criminal defense here today. But then how to carry out a social media investigation, some interesting tools that you might not be aware of. How social media works in discovery, both criminal and civil. What some of the evidence looks like. And then at the end, I'm going to review some social media ethics rules. And we might have a few minutes to go over that. Sometimes this presentation goes a little bit longer, and so therefore I might spend an extra 5 minutes or so at the end, even past 1 o'clock, making sure we have time for some of the ethics principles. And I encourage you to ask questions during the presentation. Sarah's going to keep track of those and convey any interesting questions. We have time for some questions during the development of this material. So if you have a burning question, feel free to ask it. So let's get started. These are the most popular U.S. social media sites, pages, whatever you might refer to them as, throughout the world and certainly here in the U.S. And there's a few new ones in here that you might not be too familiar with. Perhaps Reddit is new to you. The yellow ghost depiction here, of course, is Snapchat. Pinterest has been around for a while, but it's now a very popular site. These are the main ones we think of when we think of social media. And the evidence coming from these can be fascinating for both civil and criminal cases today. We're going to discuss a number of those facets. But there's also other domains or categories of social media. It's a broader based evidence form than some people might think, and so I wanted to acquaint you with some of those. But initially, I wanted to show you the popularity of these devices worldwide. The blue on this map shows us the dominance of Facebook worldwide. You can see in the Americas, Facebook is dominant, as well as Europe and Africa, also Australia and Southeast Asia, even Southern Asia. A few of the larger countries, Russia, China, have their own social media sites that we're not very familiar with, but Facebook is the name of the game here. And then if we go to the second most popular social media site worldwide, it gets kind of more interesting. In particular, here you see the dominance of Instagram, which is extremely popular these days with photo and video content. Instagram is dominant, of course, in North and South America. Also in Europe, you see it in South Asia and Australia. But notice the red. The red stands for Reddit, which is a conversational social media site that's become very popular in the last year or two. See its dominance in Canada. #2 site in Canada behind Facebook. Also Twitter in blue, Twitter in Saudi Arabia, Egypt, South Africa, and then throughout Japan and some of the other parts of the East Asia. And so interesting coverage here. So these are some of the sites internationally, and especially here in the US, we see the dominance of Facebook, Instagram, and I think probably Twitter is a tertiary. Some of these additional categories where we might find additional social media content. Picture sharing sites have been popular for a decade. Flickr was one of the first, but Facebook, of course, is dominant for picture sharing, and Instagram is kind of amounts of as well. So those are public social media picture sharing sites. But we also have sometimes more private places where we oftentimes look for photographic and visual video evidence. iCloud is huge in the Apple universe, the Apple ecology for iPhone, iPad, Mac, iMac. Tremendous amounts of different forms of photographic evidence in iCloud accounts. In the center over here, we have the Amazon logo. Amazon's photographic site is huge, very popular with Amazon customers, and lots of opportunities to share photographic information both privately and publicly at no charge. And then the big name in this area, Google Photos. Google has done an extraordinary job with the Google Photos site, especially with their advanced artificial intelligence technology that has basically provided the capability for consumers, citizens all over the world to upload thousands and thousands of photographs and allow them to be sifted, sorted, turned into timelines, turned into maps, turned into you name it. Google Photos is very popular. So very interesting locations, social media locations here if you're looking for photo and video evidence. Also local, the local scene, the community scene, very popular now for social media. You might notice for businesses, Google My Business, Yelp reviews, Foursquare for social media sites checking in and with location information especially. I found Nextdoor to be fascinating, very high growth social media site with a Nextdoor series of pages for each locale, for each city, for each town, for each neighborhood. Fascinating material shared there. So anything with a local focus, a local nexus. These are very interesting locations and they fit the category of social media. All this information can be obtained and is discoverable for both civil and criminal cases. Dating sites. This is just a short summary of a few. Match.com from years ago, some of the newer sites. OkCupid isn't new anymore, but then a lot of newer sites. There's so many here I couldn't even begin to list them all. But lots of interaction, lots of messaging, lots of photographic information. Sometimes it's shared as well in profiles. So the whole domain of its own, useful for various kinds of cases. And then direct messages. So here we see a lot of the same social media sites like Facebook and Twitter and Instagram, LinkedIn, Pinterest. The focus here is the text messages. sometimes called direct messages. These are basically text message or chat communication forms, instant message forms that are part of the social media site itself. And the vernacular for them is DM, direct message, DM me. You'll oftentimes hear. And it's a collateral source of messaging evidence that goes along with all the posts and all of the public information. These DMs are often private. And so as you look at social media, think about the channel of text messaging that accompanies each one of these large social media sites. And these DMs, these text messages or chats or instant messages are all discoverable, and they all can be obtained from the social media site, the internet service provider that actually runs the site. It can be very powerful. Also, multiplayer games. We have actually done a few forensic cases involving multiplayer games where the chat capability, the instant messages that happen contemporaneous with gameplay becomes important textual evidence. Fortnite is gigantic, huge in the world today. World of Warcraft as well. Words with Friends, they all have a secondary collateral chat or text messaging capability going on at the same time the games are played. And so these can be very valuable sources to data mine for textual evidence. Also, the large game playing platforms like Microsoft's Xbox and Sony's PlayStation, they also have a chat facility built into the platform that is broad and general. It goes over many of the different kinds of games that can be played on PlayStation and Xbox. So again, we can look to the platform for chat and text messaging. We can look to the individual games for support for text messaging. So all of these are really interesting places to look. And if you have some kind of criminal case or even a civil case that this might be relevant for, think outside the box. Think about the possibility for messages in these games. Professional social media, it's out there. As attorneys, we might be more familiar with this. LinkedIn, of course, principal form of social media that lawyers use, Avo, and then the blogging platforms, Blogger and WordPress. Also the document sharing sites like SlideShare here and ScribD. Important forms of social communication can be found there. Classmates and a lot of alumni sites as well. They all exist for professional networking and for sharing of information. And so don't overlook these in particular forms of cases that you might have. The last category that I wanted to share with you that sometimes is overlooked, I want you to think outside the box. If you have some kind of corporate case, you might find these various applications that are in use inside the institution, inside the government, the corporation, the nonprofit. Many businesses are run on G Suite, Google's G Suite, with Gmail and Calendar and contacts and so forth. Or the alternative to that, Microsoft with Office 365, for Word, PowerPoint, Excel, Outlook. SharePoint is used for a lot of internal intranet sites and sharing sites within corporations, and now Skype is part of the Microsoft world for webcams and video conferences. They also have a Teams capability now for conferencing. And then, of course, there's other sort of third-party applications like TeamViewer is popular, Basecamp for running projects, Slack, which is its own thing now inside corporations for messaging, and Trello for project management and messaging. There are so many more of these corporate or company collaboration sites that are basically social media inside the enterprise, inside the company. So think outside the box if you've got civil litigation going on. Maybe it's securities or it's employment or business cases that come up. If you've got a company involved, you might want to look at some of these other areas for social media that might go beyond just the Outlook email or the Microsoft Office documents. These are also great places to find email and messaging and chat and certainly a plethora of document types. All right, any questions about those various social media sites that might be the source of evidence? All right. This is just a visual of Facebook. It visualizes the interactions amongst Facebook subscribers all over the world. If you were to try to visualize the intensity of the interaction. And Facebook does produce a lot of evidence. I attempted to try and basically connect here the kinds of legal evidence that we look for with various kinds of data you might find in Facebook. So take, for example, party admissions. What kind of evidence in Facebook might you find that could satisfy a party admission? Well, posts could be that, emails, or even the identification of the friends of a subscriber. All of that could be an important admission in a case. State of mind, well, the status updates are very much that way. How I'm feeling right now as I do my status updates. You'll see that in a case I'm going to show in a few moments. Credibility for witnesses. What kind of Facebook data? Lots of Facebook data here. What people write in their posts or email that comes out of Facebook, the places that they visit, who their friends are, contact information, all of this goes to credibility and could be impeachable. Character, photos and videos, of course, the things that people like, the apps that they use, just a broad array of evidence becomes responsive to these various forms of evidence that can be useful. Why do I call Facebook a new confessional? Well, it lends itself by it being on the internet with a rich form of media for sharing. It lends itself to openness, to transparency, and to oversharing. Here I mentioned the speed and breadth of the communication, how quickly everything moves. And then the fact that this communication is insecure. Privacy controls on Facebook are constantly changing. It's virtually impossible to keep up with it. Sometimes what a particular privacy setting means is understood, so you have it set for yes instead of no. There's also impersonation, anonymous folks. There's all kinds of fake profiles out there and avatars and the rest. So it's hard to know who you're talking to sometimes. And then everything's happened so quickly. So there's no they're writing. Sometimes there's inaccuracies. I'm trying to understand what a post actually means or a message means. So interpretation is often left to the reader. And then, of course, there can be a lack of control. Oftentimes, if you post something, your friends will repost it or they'll send it elsewhere, retweet it, and friends of friends, and then it becomes public and it goes viral. And that happens every day. So candor, openness, transparency is the social behavior that is encouraged and actually can occur because of the technological implementation of Facebook. It can be or exonerating, and it can be powerful for use in both civil and criminal cases. I think about oversharing as a term that's often used in connection with Facebook and other social media sites. This is an example of that when a Facebook user who has a Facebook account uses their Facebook identity, their Facebook credentials, their Facebook user ID and password to log into other sites. And what happens is a connection is basically passively or by default established between Facebook as a platform for sharing with the other sites. I give examples here: Yahoo, news sites like Washington Post or The Guardian, also sites for music like Spotify and Rhapsody, video sites like Hulu and Netflix. If you use your Facebook credentials to log into your Netflix site or your Spotify site, it's possible, based on the privacy settings, that your preferences in music and video will be communicated as part of your Facebook presence. Same thing with what you read. And so it's important to be careful that you're not oversharing, that you're not sharing when you don't anticipate or plan to be sharing. But it happens. And sometimes evidence from Facebook can be found that goes beyond what the user posts or is affirmatively posting that they have the intention to post. Also, Facebook, what used to be the feeds was renamed Timeline some time ago, and now for years actually. This is somewhat outdated, but the Facebook timeline is really interesting because the posting and all of the other Facebook data now can be quite old chronologically. You see here on the right-hand side of this visual for Jane Smith, we see pictured here on the lower left a little bit about her bio, but her timeline can go back actually not only from the current year, but to a lot of previous years, all the way to her childhood. And so Facebook information can be quite a legacy buildup over the years. And if your privacy controls aren't exactly set as to what chronological period you want to share, you might actually be sharing posts and video and photo from years and years and years ago. And so there's lots of ways that Facebook information can be overshared. What about privacy? Is Facebook private? Are Facebook wall postings discoverable? Yes. This Facebook information is discoverable in spite of privacy settings or controls. And the answer is that it's electronically stored information. And electronically stored information is discoverable and discoverable means that it's often going to be. And in general, the judiciary is interested in this kind of evidence. There's a certain permissiveness depending on the case itself, but oftentimes it's admitted to establish the truthfulness of the claim and for the trier of fact to use in litigation. Privacy concerns are oftentimes outweighed by the weight and relevance, and the evidence is then found worthy of recognition. Let's switch to law enforcement. There's some really interesting information I want to share with you about the use by law enforcement of social media. Here's a couple of quotes of various law enforcement officers, and the first one being a assistant deputy attorney. The use by law enforcement and by the prosecution of social media, of Google as a search tool. Oftentimes there are routines, there are protocols in place within law enforcement for using this information. Mentions social media, mentions Google searches, and mentions here Google image search, routinely used by law enforcement. There's even something now for Google reverse image search, where you can take a suspect or an alleged victim or a third-party witness and provide one or two photographs of that person, and Google will actually try and identify that same person for you. So lots of new tools available online to establish evidence, and law enforcement is getting really good at it. You might have heard of SMILE. I'd love to ask each of you if you've heard of the SMILE conference. The idea here is social media, the internet, and law enforcement. There's a community formed. Initially, it was just in the US, but now it's gone worldwide, where best practices, tremendous amounts of sharing of best practices, even conferences are available for law enforcement, for prosecutors to share information, share tools, share best practices, share war stories, you name it, using social media to improve law enforcement engagement and reach out to citizens as well. So very powerful capability. And I would encourage those of you who are in law enforcement and prosecution roles to reach out to this very valuable resource. Also, the International Association of Chiefs of Police, very, very focused and organized, all the agencies at state, county, municipal levels, probably federal, some federal involvement as well, possibly. But the key role here that you see from these statistics is and this is somewhat dated now, the high involvement and interest by law enforcement in using social media as an important source of evidence. So prosecutor social media stories, these are somewhat dated, and you're going to be able to tell because not in this one so much, but the next two, you're going to see a couple of references to MySpace, if you can believe that. But here's an example of bank robberies, the Facebook status update posting. and someone had was oversharing this information on their status updates before the robbery, during the robbery, and after. And they were, as it says here, they were taken into custody. This was a MySpace example of the use of photographic evidence from a MySpace page. The bail was increased by a factor of 10 because of the gang association that was was established using the photographs from MySpace. Orders for protection and harassment restraining orders. We see here that the friend request, whatever social media page or site it might be, also Facebook pokes, the notion of a poke, which is basically a message with no content, that any form of interaction using social media can be construed as a violation of a no contact order. And here we have these three cases: Tennessee, Florida, and Staten Island, where the judicial outcome was that there was a violation established by use of these technological innovations for social media communication. So it's important for clients to know this. It's also important for prosecutors to be aware of this channel of evidence to be able to prove up on these cases. Criminal defense example. Also, do we have a question?
Yes, we do. We have one question from the webinar here. The question is, what are individuals' obligations regarding spoliation or obstruction, e.g., if they have a personal tendency habit to erase messages often, does that become their policy practice? Do they have to preserve messages once they realize they're possibly a party to illegal action, etc.?
Excellent. You know, I've actually thought about that, and there's much been written about that in law reviews and other places. And so I'm going to cover that in the ethics section here at the end. And so I'm going to defer, but it turns out that's a really good question, and it is an important one. And so let's discuss it in the ethics section, especially under advice that attorneys can share with their clients who might have a social media site. So so stay tuned, and we may go maybe 5 minutes, 10 minutes tops after 1 o'clock to for a bit overtime by then. But as I see, we're at 12:29 now. We're actually making good time. So let's keep going. Criminal defense examples. This is an example of the Facebook status update to actually establish an alibi. And this is, you can read this little snippet here in the PDF distribution after the presentation. But Facebook can be a valuable place using status updates for establishing the veracity of one's whereabouts. This next example, statutory rape case, again, we see more MySpace from years ago, but the young woman holding out her age as 18 by virtue of photographic evidence, and then was valuable in a criminal defense case for statutory rape. I think this is the last one on assault, video evidence. Sort of an alternate perpetrator was identified by video, again, MySpace, and the client was found, the suspect was found not guilty based on the identification of the alternate perpetrator from video evidence. And so these various forms can be used by both the prosecution and the defense, and can be extremely valuable. All right, let's switch to investigations, one of my favorite parts of this presentation, the use of social media evidence for analysis. I'm going to review a couple of what I call information bases that you might find interesting, and then problems with preservation and collection of social media because of the various forms, and then we'll talk about admissibility a little bit. One of my favorite tools for social media discovery and for investigative use is right here on this page. You'll see this is the sort of what the Google homepage looked like some time ago. And the point of this particular slide is to show that Google is a powerful analysis tool, but there's a few things you want to avoid. You absolutely want to avoid the I'm feeling lucky button where you get the most relevant hit. And you don't get to see all the other answers or hits that are available on the page, nor do you get to see anything more specific. What I recommend is what you see here circled in red is that you use Google Advanced Search. In fact, most professional investigators that use tools like Google and Bing and other search engines wouldn't even think of bringing up the tool and using it unless they used advanced search. Advanced search is so powerful because it gives you all kinds of criteria you can use to bound the search. You can bound the language, the country. You can put in all kinds of additional keywords with logical operators. You can actually search just one domain, just one website. You can search like abc.com and limit your searches. So the power for investigation in using Google Advanced Search really very useful. Minnesota CLE has some presentations usually once a year with some advanced internet research capabilities, and there's a whole unit on Google search that advocates for the use of advanced search. And I've used it very effectively over the years, but it's also useful with social media and all these various forms of sites that we've reviewed so far in this presentation. So use Google to your advantage, but stay away from I'm feeling lucky, and just stay away from the generic empty field that you fill in. Go to advanced search, check it out. And even you can find some really good education online about that. The Internet Archive, I'm wondering how many of you have heard of the Internet Archive. It goes by another name, which you've probably heard of also, the Wayback Machine. Extremely powerful. You can find it at archive.org. And what this is, it is basically, think of it as a backup of the World Wide Web. You can take a website, whether it's your personal website or a blog or a company or even social media sites, and you can step back in time and look at snapshots of that website. So you can, as it says here, retrieve copies of the public web from the past. I've used it in investigations before. It's very powerful. And you can actually utilize it on lots of different forms of websites, and it's very useful in various forms of cases, whether it's civil litigation or whether it's a criminal case. And you might somewhat be concerned about authentication, and the good news here is that archive.org actually is able to provide statements or affidavits that makes admissibility easier. They've got personnel that can help with that. They've got a procedure available for that, and they have samples available. And so I encourage you to check out the Wayback Machine, also called the Internet Archive, to find web evidence from the past. And oftentimes websites change, as you know, day by day. Evidence is taken down, it's destroyed, and so this is a way to go back and find something from the past. I also wanted to draw your attention to the Twitter archive. The US Library of Congress has basically been collecting tweets, public tweets, not the DMs, but public tweets, as far back as March of 2006. And they collected them for, looks like, 11 years, and they digitally archived them at the Library of Congress in Washington, and they're accessible. But apparently after January 1st, 2018, it got to be too much data for them, and so they started more selectively collecting them and not collecting everything that was public from Twitter. So if there's evidence that might be available from Twitter that's important to your case, there's a place you can look for it. We actually have written some software to help with the demonstration or the exposition of Twitter evidence on a timeline, and the same thing can be done for any form of social media evidence to put onto a timeline, whether it's posts or updates or what have you. Lots of different ways to demonstrate the social media evidence in written affidavits and declarations, or even in demonstrative exhibits for the trial. Online preservation and collection. So social media isn't just like a 5-page Word document or a PDF. Social media is a lot more funky than that, a lot more going on. And so there are some problems with trying to preserve it and collect it. One of the factors, of course, is that it's constantly changing, right? Wall posts can be up for 10 minutes and taken down. Same thing with status updates. The news feeds are constantly changing. All of it is very time dependent. And so collection can be a timeliness issue. Also, the evidence takes the form of a dynamic form. It's not static like a page on a PDF. Audio, of course, is to be heard, video, moving video, voice, animations, all the rest of it, multimedia, evidence in motion, and capturing that becomes challenging. Also, sometimes the content is very large, involving scrolling horizontally, scrolling vertically. You can't capture it on an 8.5 by 11 page. You can't capture it with simple screen capture tools like Snagit. So it's a much more of a challenge. And then there's apps. And the various apps in Facebook and other social media sites, they have a very dynamic nature to them. Sometimes there's metadata, and it's tricky. So there's a lot of challenges for collecting evidence with social media sites. And besides the evidence itself, there's also can be foundation and hearsay problems. The issue that often comes up when the party, the litigant, or even worse, the attorney, actually attempts to collect the evidence. There's integrity issues, and there's problems with counsel, of course, trying to serve two roles, right? That of the attorney and also being a fact witness, having collected the evidence. Process issues come up as well. The repeatability of the collection and the methods that were used and the security that may or may not have been present, that oftentimes these process issues may go to a failure to admit the evidence. The lack of chain of custody is also sometimes important in criminal cases as well, where it doesn't exist. And then the authentication might be completely missing. The methods used to authenticate social media evidence, if you just print it out, you may be missing some of these examples you see here. The name of the site, the web address, also known as the URL, a date and timestamp for when the collection was made. If the collection is made from a Mac or a PC, if it's using the Mac or PC's clock indication of the date and time, that may be completely off. And so using the US atomic clock is a much more authenticatable form. IP addresses, geolocation, all of this additional metadata can really add to the authentication. Hash codes sometimes we would use forensically, and so forth. So lots of other information might be necessary to fully authenticate social media evidence for admissibility. And they become issues up front with the preservation or the collection of that evidence. And so here we have a case from a little while ago, back in 2011, where there was a printout. And you're going to see a few examples here in these cases I'm going to show you where printouts were, in many cases, found to be improper and not properly authenticated, insufficient foundation to be admitted. And that's what happened in this particular case. Here's a case from Maryland. Question? All right. So this particular case in Maryland, murder conviction, was overturned. Again, the evidence was not properly, the photograph in this case was not properly authenticated for use here. Other courts, of course, will go the other direction, as it says here, the looking towards a more permissible approach, looking at the totality of the circumstances. And so in this particular case, a judge is reversed. And so it comes down to whether or not this evidence can be trusted if it's admissible. So moving on to discovery, what ESI is available for review from social media sites? And we're going to go to two sources where social media evidence is often found, and that is from the computer used to create or view the social media, or the mobile device, and then requests of this evidence that might be tendered within electronic discovery. So let's start and just take a look at the electronically stored information. What kind of electronically stored information or data are we talking about here for review? Well, lots and lots of content, right? Friends, connections, status updates we talked about, it goes on and on. Chat, the DMs we talked about, timelines, walls, posts, everything else, likes, and then of course photo, video, audio, music, everything else, and of course apps, lots of different apps. There's also push content. Facebook uses this quite a bit. A lot of the social media content can be sent out in email messages that you can set up with notifications. Also RSS, our really simple syndication feeds, can also be set up such that your social media environment, especially Facebook, can be sent to you through other channels. And then, of course, there's metadata in social media evidence, like the name of the site. We talked earlier about the URLs or the web addresses, date and timestamps, GPS locations for geographic information, and then the Internet Protocol logs that identify the computer or the endpoint, the device that was used for creating or for viewing the social media, when the social media site was logged into or logged out of. The metadata can become really critical in addition to the content or emails that may be sent as notifications of social media ESI. Lots of different forms of ESI depending on the particular social media site. This is an example, actually a somewhat dated example now. I actually went and got my own Facebook. As a Facebook subscriber years ago, I was able to actually download this information, and this is what the appearance of it was some time ago. But you can see here some of the initial metadata and fields that are found in Facebook. This has substantially been improved over the years, so that now Facebook information can be obtained by the subscriber in connection with the profile, all of the posting information, photo, video, all the friends and notes, events, all the messages, the DMs I talked about, not just Facebook Messenger, but also WhatsApp, which is owned by Facebook, comments. And here's some more interesting material. Facebook keeps track of IP addresses that relate to the device that was used to access it, log in, log out information, even pending friend requests, when the Facebook account might have been changed, reactivated, deactivated, disabled, or even deleted, which becomes important, especially for the spoliation question was asked earlier. This kind of information is actually tracked by Facebook and can be very valuable. We talked about pokes with OFPs and HROs earlier. This information can all be retrieved from the Facebook account. Events, more profile information, city, hometown, family members, relationship information can be obtained, languages, histories of changes to the name, very interesting from defamation cases and cases of that nature. So here we have a lot of information from Facebook that can be obtained through the tools that Facebook makes available, but also by search warrant, by subpoena, and by forensic collections as well. So lots of different methods to get one's hands on this information. So what might the evidence strategies be to get information from a computer that was used to view social media evidence or to actually create it? Well, if one makes a request for production, and the production is insufficient, then it's possible to look other places. And this is sort of a look at thinking outside the box, looking at the alternatives. Earlier, I mentioned that Facebook has quite a bit of email or a really simple syndication information that can be sent out of the Facebook environment. So that's a place to look. But quite frankly, it's more practical to move for a warrant or a court order to get the computer hard drives that were utilized by the computer to either create the social media evidence or to view it. That computer hard drive evidence can be recovered using computer forensics tools, and I want to show you what that evidence will look like. The process, of course, is to scan the hard drive to get to recover any lost, deleted, in addition to the live or active social media evidence. And it could be all the different forms that we've covered so far, whether it's Facebook or Twitter or LinkedIn or what have you. These are some of the examples. This is a quick screenshot here of what an inventory of some of that Facebook evidence might look like, whether it's live or deleted. Chat, email, the actual posts and pages, the status updates, and so forth. In addition, we don't have Google Plus around anymore, which is gone, so I'm going to take that out of my Twitter, status artifacts, LinkedIn, email fragments, Flickr, all of the other sites. This same approach of if we have insufficient social media evidence that's produced and we're more curious, we want to dig deeper, we want to try and find more, we can also go to the mobile platform, not just the computer platform where the social media evidence was created or viewed. So again, we can look to the email or the RSS that might be pushed out, but we can also do the warrant or the court order for the mobile device, whether it's a smartphone, whether it's a tablet, and go through the same approach, but using mobile device forensic tools to recover the social media evidence that was utilized on a particular mobile device. This is an example of one of the mobile device forensic tools we use here at Kearney Forensics. And this is how the information, the evidence is displayed after data mining the mobile phone. And you see here a lot of information. There's actually right here in the center, we have some pictorial information of the location information. This was a check-in. You can see here on the right, the account information. This is the last check-in here presented in the center. We have some messages from various correspondents, and then we have some web cache information. We also got some, here's the coordinate and timestamp information associated with this location. So Facebook has a pretty broad array. This is just one page of some of that information. This is Facebook Messenger as viewed through mobile device forensic tool. Here you see the sender and the remote party involved in the messaging. Here is the text message, the actual content between the two correspondents. The source is mostly the mobile device here, but sometimes it can be the web. The date and timestamp to the second is available. And you see here in this column over here, coordinates, we have GPS coordinates for the location as well as the date and timestamp for when some of these messages were sent or received. So this can be very valuable information that can be obtained from a mobile device in connection with the messaging taking place on Facebook. Here we have YouTube. And so basically here we're looking at various YouTube videos. Here we see the web addresses of the URLs of some of these videos that were watched on a phone, a history of 5 of them over here. So we can look at that. This is Foursquare, which of course the whole notion of checking into various locations that you visit throughout the day. So here we see a real focus on the coordinates. These are all GPS coordinates, latitude, longitude, which with a click, here we have the highlighted blue, we have comes up with Google Maps. So we get a Google map for this particular location showing where this this check-in that occurred during the Foursquare event, along with a date and timestamp to the second. So very useful information can be obtained through these various forms of social media sites by data mining the mobile device after the fact. Requests for any questions about that depiction? Either a computer recovery for social media evidence or mobile recovery. All right. So a request for production of social media evidence. Of course, I said earlier, this information is discoverable, and as a result, the case law is in place for litigation holds for social media using preservation letters. That can be achieved by writing to the ISP, whether it's Facebook or whether it's Twitter, what have you, to preserve that information. And then a search warrant court order can be used to obtain a return from the ISP responsive to the language in the subpoena or the search warrant. This is done all the time. We've done it effectively, and we've been happy to help out with writing some of that language that goes to the technology that needs to be recovered from the social media site, the ISP. And then in connection with the defense can do the same thing. A couple of cases here, Flagg v. City of Detroit, O'Grady v. Superior Court. The defense can get access to this social media evidence as well for various subscribers. And the defense can also ask the government, even demand from the government this information according to the various rules of criminal procedure and the Brady decision from back in '63. So Brady letters are very useful as well here. So this evidence is discoverable in a criminal context. Oftentimes another method is to be able to get a court order to be able to get the credentials for a social media site, like a Facebook account, what have you, username, the password, and oftentimes the two-factor or multi-factor token. That allows a forensics examiner, a forensics collector to be able to go into the social media site and actually collect the evidence using a digital forensics tool or a cloud forensics tool. So that's yet another method. So we have lots of different methods in connection with social media recovery for evidence. Search warrants, of course, very effective. ISPs work very closely with law enforcement, and they have actually authored compliance guides. So you'll see here available from all of the social media sites, Facebook, Instagram, Twitter, LinkedIn, Microsoft, Google. They have all written detailed documentation as to the processes, procedures, and the various forms of evidence that are available for each one of these social media sites. And you might be able to find some of these. Of course, law enforcement can request them easily, but sometimes you'll find them on the internet using Google. You can find some of these written compliance guides that are there for the benefit of law enforcement, but are also educational for other attorneys attempting to subpoena this information, whether it's a criminal defense lawyer or whether it's civil litigation. And this is an interesting point because it goes back to the Stored Communications Act or the Electronic Communication Privacy Act. The content, communications content is off limits from the standpoint of subpoenas. But the interesting point here is that these statutes were written so long ago and passed by Congress that they did not contemplate some of the newer forms, the newer types of evidence that are available in social media. By that I mean things like images and photos, audio information, video information, even links and various forms of metadata like internet protocols addresses and internet protocol logs. Some of these can be requested as content because they were not contemplated in the statute. And of course, that might be somewhat arguable, but it does present an opportunity to try and get some additional information, more avant-garde technological forms of data from a social media site or an internet service provider. Subpoenas, this is the whole notion of using a subpoena to get production of documents. The federal rules and the Minnesota rules can be helpful here. Sometimes the ISP doesn't reply or provide the return, especially in civil litigation. And so it's possible to use other methods. You see the quote here from the Facebook General Counsel. They basically hate subpoenas. And so what they have done is they've made it hard. They've made it really hard. So Facebook has increasingly additional problems that one must overcome to be able to obtain information from Facebook. They have substantial fees at multiple levels. They also have the notion of having to domesticate your subpoena in the county in which Facebook's headquarters is located. And so lots of problems there. But they have also made it easier. So I just want to finish the subpoena piece by saying that most of these large social media sites now have the capability to download the social media information. Facebook supports it, Instagram does, Google does, such that the information associated with the social media, the subscriber's profile and social media evidence, there's a way to make it accessible to be downloaded. And the social media sites like Facebook have felt the need to do that because they're trying to avoid subpoena compliance and even search warrant compliance. Less so a problem for them with search warrants, but they don't want subpoenas coming from every direction. And so they've automated the process to make the data more easily available to the subscriber. And that does present opportunities for recovery of the evidence in that way. So that is the end of the discovery piece in connection with search warrants and subpoenas. Are there any questions at this point before we jump into ethics? All right. So we're going to cover a few things in the next few minutes. We got 4 minutes until 1, but we'll go a little past 1. In connection with the ethics that apply to social media evidence. We're going to talk about communications with represented parties and unrepresented parties, and they're different. We're going to talk about agents and non-lawyer assistants as well to see if that applies goes beyond just the attorney. And then the advice that counsel can provide for clients and what they would want to consider providing for advice in other areas where they may not provide advice. And then failure to preserve, which goes to the question asked earlier about spoliation. And then I also want to make an important point about terms of service, because each of these social media sites has terms of service, and it can be very helpful from an ethical perspective. So what do you think? If you're an attorney, or you're a paralegal or a legal assistant and you work with an attorney, can you friend the opposing party to get past the privacy controls that Facebook may have? So can you get past the need to be a friend by friending the opposing party? Well, what about if you're a paralegal or an investigator? Can you do that if you're not the attorney? So what is this practice of friending to get evidence called, right? It's been called faux friending, it's been called pretexting, and it's been called oppositional research. Lots of different excuses for using this technique, but is it ethical? And the answer is, well, will you be sanctioned? And will your evidence be admissible if you try and use it? The answer is you can't do it. Lawyers may not attempt to gain access to social media site evidence under false pretenses, right? No fictitious identities. Friending someone with a fictitious identity violates the rules. 8.4 on dishonesty, fraud, and deceit. And then we've got 4.2 on communications with represented parties without the other lawyer's consent. All of this is a problem for friending the opposing party. Also, the agents, right? The paralegal, the investigator, the law clerk are also eliminated used from this same technique. The Oregon ethics opinion from back in 2013 basically says that viewing publicly admissible content is fair game. If it's public, right? If it's available to be seen by anyone, it's not restricted by privacy controls. It's like reading a book or a magazine. And San Diego County Bar Association, is that far back as 2011, basically tied in high-ranking employees of corporations as though they were represented parties. And so we can't be friending executives of corporations with a fictitious identity under false pretenses, nor can we do that with the represented parties. So we've got to be very careful there. This is very clear ethical opinions at this point. What about the unrepresented third party, unrepresented witnesses? Well, it still could be a problem with Rule 4.3 with unrepresented third parties based on the fact that the lawyer's role representing his client. There also could be the dishonesty, fraud, and deceit associated with 8.4. Various opinions from Oregon, Kentucky, and New York equally bar agents, right? Paralegals, law clerks, to bar them from false deceptive tactics to do the same. No circumventing the privacy settings here in Facebook, Instagram, Twitter is what we're talking about. The Oregon ethics opinion applies here as well with unrepresented parties, just like it did with represented parties. And then we have Philadelphia Bar Association joining with San Diego here and talking about the need for disclosure and what the rationale is, the reason for communicating with the third party.
We have a quick question related to that.
Sure.
The question is, what if an investigator uses their actual name and is the sort of person who accepts all friend requests?
Very interesting. I don't know the answer on that. I have a feeling that there are a few folks even on this presentation that might have a better take on that, but I'm not going to go beyond the material that I've carefully researched for this CLE. It's a careful area. You want to be very cautious in this space, and you might want to consult some of the Bar Association opinions and the opinions here locally in Minnesota to make sure before you take any action that's that may be outside the scope of current legal ethical opinions. So, advice. What kind of advice should lawyers provide to their clients on the use of social media? I want to draw your attention to this fascinating case, the honey baked ham case, which really shows you how bad it can go, like the damaging outcome of publicly sharing posts on social media. It's a fascinating story, and it goes on and on and on. Just like the movie that doesn't, you think it's going to end and it doesn't. That's how this case reads. And so take a look at that, and basically it shows the need for clients to get some education from a legal perspective, a legal ethics perspective on their use of social media. There was an ethics opinion here from New York County Lawyers Association that begins to suggest or hint at some of the forms of advice that might be useful, right? There may be an obligation to provide counsel, competent representation, to have counsel to review the client's social media and to provide potentially some counseling. And that goes to looking at privacy restrictions, the privacy settings that are available in Facebook and other social media. The use of those privacy restrictions might be helpful. Information that might be unwise to post, or even not to post at all, and whether or not the information is public or it might be private to friends or a larger group of friends. So to think about the various scope of visibility of posts, and then to think about what may be kept or even removed from the client's pages. And I would be very careful about the removal of that. So it's a very careful area that an attorney needs to give a good, serious consideration to in providing the advice. As I point out here, the need, of course, to balance the review of the evidence with the corresponding advice to the failure to preserve. So the idea is, in terms of visibility and then preserving the evidence, and the need to preserve evidence, especially if there's an anticipation of litigation, or if a preservation letter has been served, a litigation hold. Social media becomes just like any other form of BSI. It needs to be preserved. At the same time, it might not be prudent for a criminal defendant to leave material publicly available on a site. It's important to think through the adverse inference instructions that might come from actually deleting evidence or sanctions that may come. So the actual wholesale deletion of evidence can be a real problem. So it's really important to use care to not spoliate, not to clean the social media pages, not to delete them, or even going further to actually delete the entire account. Those are all serious problems. Facebook has a capability built in for deactivating the account with the sort of corresponding assumption that it can be reactivated later. I would be very careful there to understand exactly how Facebook works today before considering some kind of approach like this, to deactivate the account and then think that maybe you can, in 3 months, 6 months, a year, when the case is settled or when the case is over, be able to reactivate it, or reactivate it when evidence is requested by the opposing party. Be very careful there. There's even a case that goes to the point of changing the Facebook profile picture can even be a problem. And so it's some of the various elements of the evidence in a social media site may need to be preserved.
And we have a question related to that. What about just making your profile private?
Yes, I think that's a great idea, and that is you can actually limit the exposure, right? Your Facebook identity can be completely public. It can be visible only to friends of friends, or you can dial it back to just visible to your friends, or you can dial it back alternately to just visible to yourself. And it seems to me that limiting the visibility to just oneself, the subscriber, the owner of the account, is probably a pretty reasonable idea. However, I suggest to you that Facebook is constantly changing, and you really need to stay, as the attorney who might be providing counsel to a client, you need to really be up on the latest behavior, the latest way Facebook functions, so as not to get caught in some kind of trap. And so just be very careful. I think that one is pretty safe, but as a method to reduce the visibility of the material, the social media ESI, but on the other hand, really dig in deep. Spend some time reading the documentation, understanding. You might even want to do a Google search on the current behavior today, 2020, of how this works before you give any advice about how Facebook operates. They're constantly changing it behind the scenes. Facebook is updated daily in terms of how the various features and functions behave. And then my last bullet point here is also think outside the box. Don't fail to preserve rare but relevant social media, right? We talked about the gaming sites, we talked about dating sites, all the company sites inside the enterprise, all of the DMs. So if you get a preservation letter from the opposing counsel, or you get a litigation hold, it's not just Facebook, folks. It goes way beyond that. It's not just Facebook, Instagram, and Twitter and LinkedIn, the big four. No, it can go to scores and scores, maybe even 100 different social media sites that you might need to think about that could become discoverable, could become requestable by the opposing party. And there are a number of folks who are really into this approach towards social media evidence. So you don't want to be caught flat-footed. You save the social, made sure Facebook was saved, but there may be another 50 social media sites that may become discoverable, that may be relevant to the case. So think outside the box. I wanted to draw your attention to terms of service. Facebook has a pretty interesting terms of service. There's a lot of things as a subscriber you cannot do. I've highlighted some stuff here by bolding it, who can use Facebook. And there's some basic things that need to be observed, complied to by the subscriber, right? Use the same name that you use in everyday life. So if you violate that, then that may change the nature of the case. Creating only one account, accurate information, not sharing your password, and notice here the last series of bullets. These are behaviors that you cannot use Facebook, right? So there's an age requirement. If you're a convicted sex offender, previously disabled your account for various forms of violations of the policies, and then prohibited from various products and services. So there's lots of rules. And those rules, you need to make sure that your client doesn't violate these rules in connection with their use of Facebook, or there may be the evidence that is captured might be able to be used in various ways against your client. So this area of providing advice for the social media site, well, it being an important area of the representation, needs to be handled very cautiously and with a great due diligence on behalf of the attorney to make certain that the advice one is giving is balanced and it's good judgment and it's accurate as to how the social media site is behaving at the present time, or at the time the site, the contemporaneous nature of the behavior with the actual case, any incident that might have occurred. So to conclude, given it's 10 minutes after 1, so the whole idea of this presentation is to be aware of social media evidence and the usefulness of phones and computers to be able to access social media evidence. Thinking broadly, thinking outside the box as to where potential admissible evidence might be, and then the timeliness of that, because social media evidence is so dynamic, and mobile devices, quite frankly, are so dynamic, the need to act quickly and timely to be able to collect it and analyze it before some of these things you see listed here happen. right? The content might change, the privacy controls get tightened up. Something that maybe was public yesterday, today may be available only to friends or just to the subscriber, him or herself. And the whole notion of friending may change. Third-party witnesses may be defriended. The wall posts may change. And it can happen. Sometimes the social media account just goes missing. It's terminated. And so the idea is to act on social media evidence quickly so as to be able to get the most probative return possible. So I thank you for actually staying with us for 11 minutes past 1. If there are any other questions that would be important to ask, I'd be happy to try and answer them if anyone wants to stay on this call for a few more minutes.
I'm not seeing any other questions at this point.
Very good.
We'll give it another minute or so if anyone else has questions to enter in the chat here. Otherwise, then we'll conclude today's CLE.
Thank you, everyone, for your attendance.
Thank you. It was very good. Thanks a lot.
You're most welcome. Thank you.
Bet.
All right, well, since there are no questions, we'll go ahead and end the presentation and the recording and close out the meeting. Thank you so much for attending.
Thank you.